was this young girl was returning with her mother from a relative's place when two men offered her a lift, assuring that they would drop her home. What did they do instead? One of these men grabbed the girl's breast, the other broke the string of pyjama and tried to drag her beneath a culvert. But when this was brought up in court, the Allahabad High Court judge said that this does not amount to an attempt to rape. Justice Ram Manohar Narayan Mishra noted that there was no material on record to show that the accused men had determined to rape the girl. The observations have sparked outrage across the country. The legal fraternity as well as the political class have both expressed anger.
They speak in a double language. On the one hand, they seem to be encouraging the participation of women in society generally. And on the other hand, the judges in their judgments make comments like this, that grabbing their breasts and untying their pajamas is not an attempt to rape. What else is it?
I personally feel that this order of Allahabad High Court is absolutely bad. At the stage of dealing with something order, you have to accept the facts as it is.
Allahabad High Court has said that this is not rape. So should we wait for rape to happen to it to be called rape? I mean, I think the definition of rape is very clear. Even if a woman's private part is touched, it is rape. That's the new definition of rape. I do hope that the Allahabad High Court is going to retract its order.
The Samajwadi Party strongly disagree with this kind of argument. क्या हम बेटियों का महिलाओं का रेप होने का इंतजार करेंगे? अटेम्प्ट टू रेप की धारा नहीं बनती है. तो महिलाओं के बारे में समाजवादी पार्टी बहुत ही जेंडर को लेकर बहुत ही सेंसिटाइज है.
You're watching the News Hour at 10, debate number 3 on Times Now, Super Prime Time.
And for more on this, we have a panelist joining us. Karuna Nandi is Senior Advocate of Supreme Court. Rizwan Siddiqui is an advocate from Mumbai joining us live. Rizwan Siddiqui, let me just read out what has specifically been written in this order. This is paragraph 24. In order to bring out a charge of attempt to rape, the prosecution must establish that it had gone beyond the stage of preparation. The difference between preparation and actual attempt to commit an offence consists chiefly in the greater degree of determination. This is what has been stated by the judge. Now, what really constitutes this preparation? These are acts which, the entire judgment has sparked off this huge debate nationally. People are absolutely outraged and incensed by this kind of insensitivity, perhaps, that has been shown by the judge by using these words.
See, I completely agree with the sentiments of the people, and that they are hurt by what they have read from a part of the order. And I do not disagree at all that the order, when it is read to general public, they would not be very happy with what they are, reading and what they are understanding. They probably feel that the High Court has not been sensitive to the entire issue. But on the other part, as an officer of the court, I have a different take to it. The criminal law is based on mens rea. Mens rea means the guilty act accompanied by a guilty mind. So the part of preparation that the judge is talking about, that the honorable judge is talking about, is a part which he wants to establish whether there was mens rea or there was no mens rea. So though there is, on the one side, they have people's sentiments, on the other side, there is a law. There needs to be a balance.
Let me stop you right there. Just let me stop you right there. Do you know why no such act happened?
Yes.
It's because there were some passers-by who were later witnesses in this case who actually came to stop them. So those persons who are the accused in this case had to flee. How does that take away their intent then?
See, now, if you look at it, I mean, if I have to discuss this as a lawyer, just because there was a girl, see, I do not know the entire facts of the case. Now, whatever little knowledge that I have of the case through the media, I will discuss it with those limited knowledge. The issue that I see here is that the girl was not known to the accused parties, and that she was with her mother, and the people who attempted to sexually assault her in whatever form and manner, had no intention, because they did not know of the girl. They did not know that they will come across. So there was no preparation at hand. They may have fled the situation. They may have gone and done whatever they must have done after that.
Mr. Siddiqui,
but when there is
these very fact that they committed such acts, I mean, where is the question of preparation? Anyway, I'm going to allow Karuna Nandi to come in on this. Karuna Nandi, I want you to respond to the question of intent and preparation and the fact that they were not known allegedly. Please respond to Rizwan Siddiqui's arguments.
I won't respond to my co-panelist's argument. I will respond to the judgment. So my knowledge is not from the media. My knowledge is from the judgment, which is public. Firstly, the court at this stage, and there are a large number of Supreme Court judgments that are perfectly clear on this, has gone beyond its jurisdictional ambit. What it has done is at the summoning stage, it has, suo moto and for no good reason, opined on what the mens rea was, where there was absolutely no need to do so. While it has gotten rid of the rape charge, and that is absolutely correct because there was no allegation of any penetration. To say that there is, after giving a thoughtful consideration and meticulous examination of the facts of the case, the court is of the considered opinion that the mere fact that according to the prosecution version, two accused, Pavan and Akash, grabbed the breasts of the victim, and one of them, namely Akash, broke the string of her pyjama and tried to drag her beneath the culvert. And in the meanwhile, on interference of passerby's witnesses, the accused persons fled away from the spot, leaving the victim behind, is not sufficient to hold that a case of Section 376, read with 511 IPC, is made out, etc., is made out. This is just wrong. It's just incorrect. It's an incorrect reading of law. The fact that he had to go back to 1881 to cite Express versus Shankar, which said that we believe that in this country, indecent assaults are often magnified into attempts at rape. That the fact that he had to go back to Rex versus James Lloyd back in 1836 and say that in order to find the prisoner guilty of an assault with intent to commit a rape, you must be satisfied that the prisoner, when he laid hold of the prosecutrix, not only desired to gratify his passions, look at the nonsense language, upon her person, but that he intended to do so at all events and notwithstanding any resistance on her part. This is all pre-constitutional. This is pre-Article 14. Okay. This is Article 15. This is prior to all of the judgments of the Supreme Court. It is wrong, egregiously wrong.
Okay, and this is not an isolated case. Yes, Karunanandi, your point there is valid because, Rizwan, in 2020, we all know what happened as far as the Bombay High Court judgment which spoke about skin-to-skin contact. What happens after a lot of outrage similar to this case? The Supreme Court undid it. The larger question is, when you make such, observations as what is the preparatory stage, etc., in an attempt to rape case, you're setting a very, very dangerous precedent in terms of opening it up to interpretation by making these kind of comments, which, as the previous speaker said, is quite irresponsible.
Not to get into unnecessary debates here, but what I see is that there are two types of judgments, reportable and general non-reportable judgments. Now, this particular judgment that the High Court has passed is while it was dealing with the facts of this particular case. And what did it see? What exactly did it observe? Why did it pass this particular judgment? My co-panelist has read the order very carefully, which I have not. So I will not be in a position to argue it the way she is doing it. But nonetheless, from whatever I've understood through the media, what I particularly feel is that there was something that weighed on the judge's mind when he passed this judgment. He read something, he saw something, there was some material available on record, which I'm not privy to right now. But I will not say, very, very blatantly that just because it is not suiting the sentiments of the general public, or it is not suiting the sentiments of the complainant, I should say very, very narrow-mindedly that this particular judgment is bad in law and there was non-application of mind. I don't think I should do that. So, I will leave it to that only.
Well, Rizwan Siddiqui, if lack of knowledge of law is not a valid legal argument in court, I would only say that lawyers perhaps should read judgments before they come to debate them. But I have a simple question to Karunanandi. Karunanandi, is this going to set a dangerous precedent simply in terms of people coming out and reporting such cases in the future? Because if this is the kind of judgment that exists, and if this is not struck down by Supreme Court, we can't second guess what the Supreme Court will do, of course. But does this create a real fear in the minds of victims, for instance, in future situations?
There are reported judgments and then there are unreported judgments. But these judgments, this judgment, because it's not restricted to its facts, and this judgment, because it has a neutral citation number, 2025 Allahabad High Court 37075, is a judgment that can be cited. There's absolutely no doubt about that. So not only does it give out the wrong message, it also sets a very bad precedent. But most importantly, there is a complete miscarriage, not just of law, but of justice. So therefore, yes, one hopes that this will be corrected at the appellate stage. But far more importantly, and having read the judgment carefully, I will say this, and I say this with responsibility, that when this kind of judgment is passed, and I speak not only of the fact that the judge has, for some reason, and I think it's perhaps suo moto, said that the attempt to rape is something that, a charge that shouldn't be framed, whereas it seems to me that the prosecution and the defense were only on the point that should the charge of rape be framed. Now, of course, if there is no claim of penetration, then the charge of rape in any case cannot be framed. But if the arguments were only on that, and for some reason the judge in the Allahabad High Court decided that the attempt to rape should not be framed, then that is a problem. Another thing that is a problem is that why was it being treated as a complaint case when all such complaints under Section 166A of the IPC, which was in force at the time, have to be registered by the police, and because it is an offence against the state, and the state must investigate it. Why was it a complaint case in the first place? And most egregiously on the facts. And here the general public is not always right. Sometimes the general public is completely wrong, right? We have to go by the law, and the law as interpreted through the lens of the Constitution. It is rightly said that our rights, our most fundamental rights, lie in the CRPC and the IPC. And so when a judge goes beyond all of this law and sort of makes it up, then I think that just the appellate process is not sufficient. Either there should be, he should be pulled up by the Supreme Court or by his Chief Justice. But in addition, that is not sufficient. There are trainings at the National Judicial Academy, and I think a short suspension and a retraining is something that should be a matter of course when you have judgments like this. And I also think that people are appointed to such important positions that interviewing sort of the people who we most look to enforce the law. We should have some kind of evaluation of how they deal with gender, how they deal with casteism, how they deal with communalism, you know, and then take a call.
Absolutely. I think that's a very, very valid point. At the end of the day, Rizwan, this is somebody who's a member of the higher judiciary of this country. And therefore, it's only natural that one will hold them up to a higher standard. And, the very fact that the entire power dynamics of this have been completely, ignored. The fact that the victim is a minor, the fact that there were two men who were there over there, her own vulnerability, rather than, and, the subtext of this is that you're actually sort of arguing, saying that there was no serious assault and therefore this is fine. Were they waiting for a serious assault? One expects far more sensitivity from a person who's a high court judge rather than this sort of patriarchal attitude. And this really shows that patriarchy is very much alive and kicking as far as the higher judiciary, at least sections of it, are concerned.
Sections of it?
Well, yes, as the highest... So, yes. As far as the Constitutional Court, when the High Court is acting in a capacity of a Constitutional Court and being the highest court of the state, it is duty-bound to ensure that there is a proper balance, and they are also duty-bound to ensure that justice has to be delivered right at the very beginning, right from the very beginning at the first stage itself. There's no doubt about that. And I will also not deny the fact that if there is any lack of judgment here on the part of the High Court judge, then of course he has to be pulled up. My only limited point that I was trying to bring out here, as I mentioned earlier also, since I did not get the opportunity to go through the order in detail because I was just rushed into many things and then I came here for the interview directly. So therefore, my arguments, in this particular debate was very limited to the points that I was basically shown. I was basically told in the parts that I normally read through the entire, through my journey. So maybe my points that I was trying to bring out was only on the law part, not on the fact part. Okay, as far as the facts are concerned, my co-panelist, I think she is much more aware than me as with regards to the facts. So therefore, I will not deny that, yes, what she's trying to say is right. Okay. My only point, yes. I was only talking about the point
I'm
of
going to give
how
the
we
last
need
word to
deal with
Karuna.
it.
I'm going to give the last word to Karuna. Karuna, 30 seconds, quickly, please.
The law is clear. The law has some rights that are built into the Criminal Procedure Code and to the IPC. Today, the BNS and the BNSS. When a judge fails to follow that law, what happens is that the misogyny and the patriarchy and the violence that we have in our society gets reinforced. And we cannot have the state approbate the violence that.
Right, absolutely, absolutely. Very, very shocking judgment. The outrage perhaps is only to be expected when this kind of a statement comes in from one of our high courts, particularly the Allahabad High Court, which is a very renowned court as well. Karuna Nandi, Rizwan Siddiqui, I'd like to thank both of you for joining us on the show this evening.